Uganda 24/7 YouTube channel. Please subscribe, share and comment.
Allow us the latitude to apply for bail for the accused person. Please proceed. Your Worship, the accused person is presumed to be innocent. Until when the prosecution has proved its case. To the satisfaction of court and beyond reasonable doubt. On the basis of presumption of innocence, Your Worship, I pray that the accused person be granted bail there is a certain uncertainty as regards when the trial will commence, and in the likely event where the proceedings will end in favor of the accused person. Your Worship, in case he remains behind jail walls all that time, he will have suffered irreparable loss, Your Worship. The offenses with which the accused is charged are available, Your Worship. The accused Your Worship, the accused person has a fixed place of abode. That is Lusaka village, Machinde division, Kampala. He is a journalist. He is 34 years old. His phone number is 0701 87 09 59. Your worship, we pray that you invoke your discretionary powers considering the presumption of innocence. The gravity of the offenses with which is charged. And the fact that the accused person has never been charged with any offense, Your worship. Your worship, on the court record there is an introduction letter from the local council where the accused person resides. Your worship, there are 3 sureties who are to be presented by my land friend is Bw'Atabukidde.
We represent the facility, worship Ali Muyanyama, Masigi Nganda Muyanyama, and appear for special report. We worship the surety is 856, the resident of Osaka, his name, Masigi Nganda Ali. Worship is age 56. Is resident of Osaka. Actually, one. Actually, about once. The accused person is an electorate and a long-time friend. Worship. It is the mayor of Machinge, Division, and Council. Where the court has jurisdiction. His telephone number. Zero 751 632 51 632 7 covers Moses Wilberforce. The worship covers 856. The worship covers Moses Wilberforce. 846. Covers with you. Is here. Is the resident of the Laba. The Laba he is a brother. That is the person. He's a businessman owning a bank. Together. His telephone number Laba, Club Pentable. Second number is 772, 47, 48, 80. The roll and the last surety is Kadu. Kadu Charles. Your worship is a resident of Osaka. The resident is telephone number is 52 25 00 20 0772. Your worship 25 00 Your worship, there is a long time frame. And he's a businessman dealing in clothing, boutique, owns a boutique. Your worship, we find that the sureties are sufficient and substantial. And when we find them sufficient, we invite this honorable court to invoke its discretion to find the sureties substantial. Your worship, we have explained all their obligation to them, and they appear to have understood. Your worship, we pray for favorable conditions and most encourage delays in an appeal. Your worship, we so pray.
Do you want to add
Having in mind that the offense which this person is charged with is bailable, as stated by the council for the accused person. It is also noted that the bail is not automatic, much as it is bailable. There is discretion of the court. Let us grant bail or deny bail. That is entirely at the discretion of the honorable court. But the discretion is supposed to be exercised judiciously. The court has to take into consideration when it grants bail public interest. Whether the public interest also demands the accused person to be released on bail. Once we talk about the offense we which the accused person is charged with, it is bailable. Yes, it is bailable, but it is also serious in nature. And that one that we really have to know is a serious offense which affects actually. It can even affect the entire country. It affects the public. Much as is presumed innocent. We are not condemning that he's already guilty, but that's the fact. The council also cited the uncertainty as to when this matter will be tried as one of the grounds that the applicants should be granted bail. I wish to remind the council that when the accused person appeared in court, we already informed the court that the inquiries are complete. This matter was not fixed for hearing, basically because we were out of time, and today it was fixed for bail application. Counsel for the accused person tried to apply for bail, but due to time, it was deferred today. That does not mean that the inquiries are incomplete. Prosecution is actually ready to proceed with this matter and have it handled expeditiously. So that one should not be a factor for the applicant to be granted bail. The council also stated before the Senate report that the applicant has a fixed place of abode. I wish to inform court that this applicant, when he appeared before the police officer, the first thing is to establish his place of residence. And he stated that he's a resident of Chanja, that is in Nakawa division, captured in the charge sheet. And that one was his first full particulars, and also gave his phone contact in regard to that. But today, council has come up with another contradicting information with regard to the resident of the applicant, saying that the applicant is a resident of Musaka village. Urban Council is marking division, different division now from Nakawa to marking, that's I don't know when it's shifted, but now it's in marking division. So also these are not raised issue of doubt as to whether the applicant has fixed place of abode. Is in doubt created by the applicant himself or the lawyer. But the fact remains that applicant's fixed place of abode is in doubt. I pray that court should take into consideration that when granting bail, then the first surety for the applicant is said to be the mayor of this division. A mayor is somebody who owns duty to his subjects, being it the complainant, being it the accused person. The mayor owns duty for them as their mayor. So there is a conflict of interest. Mayor, as a surety, may fail to discharge his obligation because his interest will conflict. He has the complainant who are also his subject. The accused person also is a subject to mayor. Mayor is the head. In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say, let me support the accused side. How about the other one? They are also yours. How will you handle it being the mayor of the division? That's the issue to be taken into consideration. In that circumstance, I pray that the mayor should be found. The mayor should be found not substantial to send the security for an accused person. Reason being, he also owns duty for the others who are the side of the complainant. It will conflict. Then the two sureties was tendered by the accused person. These are the sureties that the person produced them, but they were just friends. They are friends. So in an event, yes. But the third surety is a friend, just a friend, as I've mentioned. So in event, the accused person happened to jump court bail, he may fail to discharge his duty as a surety, which the council for the accused person informed the Honorable Court that they were being taught of their duties as a surety. But to me, he may fail to discharge. His duty being a friend may not be able to trace the accused person. Even the accused person runs to the village, how will you trace the accused person? He may fail, just a friend in the city. been failed. So on that ground, and for the interest of justice, it's my humble prayer that this bail is denied, the matter is fixed for hearing, and is handled expeditiously as his faith is determined. If he is found innocent, find guilty. The faith is determined. I so pray also.
Briefly rejoin your worship. We have not contradicted the prosecution as regards whether the inquiries are complete. What we have stated, your worship, is that we are uncertain as regards when the trial will commence. We are also uncertain as regards when this matter will be concluded. Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty. Your Worship, my land sister for the prosecution has submitted to the effect that there is a contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines that every applicant should have an introduction letter as regards to his residency. The framers of those directions were aware that the prosecution normally indicates on the charge sheet the residence of the accused person. Why would it be required again for one to have an introduction letter? The accused person is at liberty to contradict the findings of the prosecution. Your Worship, on the court record, there is a letter by the local council authority confirming the residence of the accused person. And that residence is within your jurisdiction, Your Worship. Being Lusaka village in Machinda division, Kampala. Had we cited the information in the charge sheet, my sister would have objected, saying that they have not produced an introduction letter from local council authority. The information on the charge sheet, Your Worship, is a subject of scrutiny by this court. And that will come at trial, Your Worship. And that is information from the prosecution, not the accused person. Because the prosecution has as well confirmed that our client is a resident of Machingi. When she raised an objection against the mayor, Ali, being the surety, one of the sureties, saying that he will contradict his interests in regard to the complainant and the accused person, since both are his residents in the Machingi division. That he owes a duty to both. Your Worship, isn't that a clear indication that the accused person is a resident of Machingi? As regards the mayor having a challenge of contradicting interest, Your Worship, Myland sister for the prosecution has not cited any connection between the mayor and the case before you. Is not one of the witnesses or potential witness. And Your Worship, the accused person is still innocent. There is presumption of innocence which he enjoys. Should the mayor be judgmental at this stage that this person is likely to be found guilty at this stage? My land sister is stretching beyond the limits. I invite you to reject that objection. Lastly, Your Worship, my land sister for the prosecution has stated that a friend being a surety, that he may not execute the duty. That is speculative, Your Worship. There is no proof in that regard, Your Worship. He's saying he's likely, he may not, but that is speculative, Your Worship. And Your Worship, the court should not rely on such baseless objection to deny that accused person bail. Where the law does not define the relationship, which kind of relationship that must exist for one to be a substantial surety. In our practice, Your Worship, friends have been standing as sureties for accused persons. In that regard, Your Worship, I invite you to ignore and reject the objections raised by my land sister for the prosecution. Grant bail to our client on lenient conditions. Yes, we agree that a bail is not automatic, but Your Worship, the constitutional commandments are clear that when the needful has been done, including presenting substantial sureties, as we have done here, court may exercise its discretionary powers and grant bail. We pray that you invoke your powers as provided for under Section 76 of the Magistrate Courts Act and grant that bail. We so pray, Your Worship.
Salamu alaikum. Agati nakalemba omusemi w'edduwa. Bw'oba wenyiye embeera embi yankusomere ku dduwa. Abali ebweru mirimu gigaanye papula zeesibye kino kyekyoto kwesabira omukisa kobe ng'odiriddawa wali wenkusabira n'ofuna emikisa. Ky'oba olaba ngabirira ebinyonyi ebitalina kyakulya naawe atalina mulimu jangu kusomere ku dduwa ofuna omukisa. Eno ennyanja kwesula buli kimu ekisira ne kiba kikujjudde nekikasuka mu nnyanja nekikunta ne kigenda. Nze Agati Nakalembe kambawo ennamba yange yeeno 075237529. Temuddeeyo ne mwebakira ebizibu mukobe ku nnamba yange eno.
Charges or until is found guilty by a court of competent jurisdiction. It is this presumption of innocence that gives the accused person the right to apply for bail. But like it has been stated by the state attorney and it's the position of the law that to grant or deny this bail is at the discretion of the court. With discretion, court must exercise viciously, that is to say fairly and reasonably. The state objections relate fixed place of abode for the accused person argument is that the accused person informed police officers that she is a resident of Chanja, which is in Nakawa division, and the introduction letter that he has presented through his lawyers today shows that he is a resident of Lusaka, marking a division. Argument is that these are two totally different divisions. She also objects in first surety for reasons that is a mayor who will be in conflict of interest because he is both a complainant and the accused person. The other objection relates to the third surety being a mere friend, that he may not be in position to execute the duties of the sureties. Consider the arguments made in the rejoinder. The first of all, the requirement of the accused person presenting an introduction letter from the area LC1 where he resides was brought by the bail guidelines. And I want to argue with counsel for the applicant that the framers of these guidelines knew that that information can be found in the charge sheet, but they put this as a requirement. And since the accused person has presented an introduction letter that has not been withdrawn by the author, this court shall take information therein to be authentic and the place of abode for the accused person. The second objection relates to first surety being the mayor. I do not see any conflict of interest here. I do not see any conflict of interest by this surety. The other one relates to the third surety being a friend. Whereas the ideal should be people who are closely related to the applicant, but in circumstances where a person is presented much as just a friend, would support these people. These substantial sureties. The sureties are formed, substantial. All the three sureties presented are formed, substantial to this matter. For reasons that the accused person pleaded not guilty, is presumed innocent. He has presented three sureties that this court has found substantial. This court is of the view that the accused person will be granted bail as a hereby do. The accused person will be granted. These are the terms. It's granted bail in the following terms. He's going to execute a cash bond of 500,000 Ghana shillings. That is, shall execute a cash bond of 500,000 Ghana shillings. Each of the sureties presented shall execute a non-cash bond of 5 million. This is non-cash, 5 million Ghana shillings. This matter is accordingly adjourned to 2nd of October. 2nd of October shall be called at 10. 2nd of October at 10 a.m.
Much obliged, Your Worship.